let me kick off. Good evening, everyone. My name is Liz Snodgrass, and I'm a partner at 3 Crowns. On behalf of the firm, and together with our friends at Columbia Law School and King's College London, it's my great pleasure to welcome you to the 10th annual David D. Caron Praelium here in the beautiful Harmonie Club in New York City. It's hard to believe that what began, of all places, in a Starbucks near Aldwych in 2014 is now reaching its 10th edition. Back then, one of our founding partners, Guyton Verhusel, Professor Federico Ortino, and the late Dean David Caron shared the simple idea of creating an annual event that would celebrate the art of advocacy, not just as a skill, but as a cornerstone of international justice. With Professor George Bermann's early support, the Praelium was born, and it has since alternated between London and New York, bringing together advocates, arbitrators, and students from around the world. Now, for those joining us for the first time, or like me, without the benefit of having had a classical education, I can tell you that the name Praelium is, of course, Latin, and I can tell you that it means battle or trial of strength. But what lies ahead this evening is no ordinary contest. Tonight's struggle will be fought not with weapons, but with words, wit, and persuasion, a clash of ideas that reminds us why advocacy remains one of the most compelling forms of performance there is. Presiding over the battle of minds is our highly distinguished tribunal. Samaa Haridi of King & Spalding, who will be president this evening, Judge Charles Brower, and Professor George Bermann. Samaa, Professor Bermann, Judge Brower, we're honored to have you with us. And as in every Praelium, we are fortunate to have 2 exceptional advocates to lead the charge. Appearing on behalf of the claimants is Anneliese, KC of Fountain Court Chambers, and for the respondent, Patrick Pearsall of Gibson Dunn. Both are renowned for their eloquence, clarity, and courtroom presence, so we are certainly in for a true masterclass in advocacy this evening. Before we begin, let me briefly set the scene for those of you who may not have fully absorbed the record. This might be summarized as a tale of trouble in paradise. The case involves an ICSID arbitration between Mr. Sean Patton, a native of Taslandia, and the local government of Maui in the U.S. state of Hawaii. The dispute arises under the U.S. Taslandia Bilateral Investment Treaty. Mr. Patton claims that Maui unlawfully expropriated his investment and breached its obligation to provide fair and equitable treatment after it terminated an agreement to redevelop a luxury resort in Maui. The government argues that the entire project was tainted by corruption and therefore void from the start. Now, the fact pattern of the story begins rather innocently. Fresh off his wedding, Mr. Patton and his wife Raquel went to the White Orchid, a luxury resort in Maui, for their honeymoon. When their suite was double booked, Mr. Patton, frustrated and egged on by his influential mother, decided to buy the hotel outright and later turn it into the Papaya Colony, a high-end resort designed just to his liking. In aid of this, he signed an investment agreement with the local government of Maui. It required environmental approvals from neighboring areas, including land used by native Hawaiian communities, and it included an ICSID arbitration clause, applied U.S. federal law, and selected Washington, D.C. as the seat of arbitration. Soon after, protests erupted, followed by rumors of shady consultations at the hotel bar. Things took a darker turn when the body of the former hotel manager was found offshore, and investigators alleged that Mr. Patton's mother had bribed officials to push the project through. Although a U.S. federal court later confirmed that Mr. Patton had valid permits, 2 officials were subsequently convicted of corruption, and Maui terminated the agreement, choosing instead to convert the site into a papaya farming cooperative. Now, Mr. Patton denies all wrongdoing and has brought an ICSID claim for $4.2 billion, arguing that his investment was legitimate and that the government's actions amount to unlawful expropriation and other breaches of the treaty. Maui, for its part, maintains that corruption invalidates the entire project and removes it from treaty protection. The tribunal has asked the parties to address 2 questions. First, whether the dispute over the validity of the environmental permits is admissible given the earlier court decision as to their validity, and second, whether the alleged bribery makes the investment illegal from the outset, excluding it from investment treaty protection. As always, the goal tonight is not victory or defeat, but illumination to showcase how great advocates persuade, how arbitrators probe, and how our discipline continues to evolve through the art of argument itself. We're deeply grateful to our partners, Columbia Law School and King's College London, for their continued collaboration, and to all of you for joining us this evening to celebrate the legacy of Dean Caron, whose intellect, humanity, and belief in the power of advocacy continue to inspire this event. With that, it's my great pleasure to hand the floor to the President of the Tribunal, Samaa Haridi. Thank you.
Thank you very much. Good evening, and let us start with our hearing today. Let me know if you can't hear me. I think you can. I understand, based on our discussions and the agreement during our pre-hearing conference, that counsel have agreed to begin actually with issue 2, which is the issue, the jurisdiction and the question of the illegality of the investment, which respondent will address first for 10 minutes. Please proceed.
Good evening, Madam President, members of the Tribunal. My name is Patrick Pearsall, and I'm appearing for a one-night-only command performance on behalf of the respondent, the United States of America. In my limited time today, I'll be addressing you on 2 issues. First, the jurisdictional matter, whether the payment of bribes to U.S. government officials renders the alleged investment made by Mr. Patton illegal ab initio, and therefore barred from protection under the ICSID Convention. And then the second point will be after Ms. Day's jurisdictional point. I'll address you on the admissibility question. But in general terms, our position is this. First, this tribunal does not have jurisdiction over Mr. Patton's claims because the payment of bribes to government officials renders any investment purportedly made by Mr. Patton barred from protection under international law and under the ICSID Convention. And first, let's start with the legal standard. This tribunal's jurisdiction is governed by Article 25.1 of the ICSID Convention, which requires claimants to establish 4 basic conditions. The arbitration must be between a contracting state and a national of another contracting state. There must be a legal dispute. This dispute must arise from an investment, and the contracting state and the investor must have consented in writing to the dispute resolution clause. It is respondent's contention that claimant has not satisfied this third element. Namely, it has not made an investment in the United States. And it appears now settled as a matter of international investment law that an investment not made in good faith, an investment made through corruption, is not an investment under the ICSID Convention. And this was the specific holding, of course, by the tribunal in Phoenix Action versus the Czech Republic in 2009, where the tribunal found, and indulge me as I quote, that the purpose of the international mechanism of protection of investment through the ICSID cannot be to protect investments made in violation of the laws of the host state or investments not made in good faith. And then, of course, the tribunal went on to propound that good faith includes misrepresentations, concealment, or corruption. And of course, the Phoenix Action Tribunal was standing on the shoulders of other tribunals, notably, of course, the World Duty Free v. Kenya Tribunal, which famously declared, in light of domestic laws and international conventions relating to corruption, and in light of the decisions taken in the matter of courts and tribunals, this tribunal is convinced that bribery is contrary to international public policy. And it is a general principle of international law, indeed we would go so far as to say perhaps it's a customary international law principle, and at a minimum, an obligation that exists independent of the language of any specific treaty, that an investment obtained through corruption must be void ab initio and cannot be protected under the ICSID Convention. And there are good policy reasons for this as well, and the tribunal should continue to recognize that principle. Investors must be disincentivized from committing corruption to the greatest extent possible by making the investment through corrupt means unable to have protection under the international regime. And
So, if I may, you mentioned a line of cases, including Phoenix Action, but you, I'm sure, are well aware that there are other cases. There are cases such as Metaltech v. Uzbekistan, which take a different view and a different approach in terms of the assessment of the investment and the question of whether it's an objective or subjective one. What is your position on that, and why should we disregard that other line of cases?
yeah, and we recognize that the tribunal in Metalclad did state that the ICSID Convention articles did not include a principle of good faith. But the Metalclad tribunal, of course, went on to recognize that, quote, a breach of the general prohibition of the abuse of right, which is a manifestation of the principle of good faith, and I'm quoting there, may give rise to an objection to jurisdiction under international law. And while we take issue with Metalclad not finding the principle of good faith as part of the ICSID Convention investment prong, it is beyond doubt that it also states that with regard to general principles of international law regarding good faith, the result is the same. The tribunal does not have jurisdiction over claimants' claims.
Well, I have a question, if I may. As I recall, there was an action brought against Mr. Patton's mother for having committed bribery. Now, she was exonerated, right? What significance does that have, and why was she pursued and not Mr. Patton?
It is not my understanding that an action was brought against either the mother or the son. It was an action brought against U.S. government officials. But the point there is international law looks to the investment, not the investor. And there are good policy reasons for that. And the policy reasons for that is it goes to the core of the agreement to arbitrate. It goes to the core of why states agree to promulgate this field without privity, right? The investor is not the focus for the state. The state is focused on the investment. That is what they are getting from their bargain, and that is what international law asks us to look at.
Except for the fact that, that's fine, except for the fact that his mother was pursued, and she was a defendant in that action.
Well, the point here is the investor is Mr. Patton. And he has, the question of his complicity in the bribe, or even his mother's complicity in the bribe, which is demonstrable by the evidence that was brought in the district court. Irrespective of that complicity, international law looks to the investment.
Okay.
And there's good policy reasons for that.
Okay, so it doesn't matter whether he or his mother paid the bribe.
That's correct. That's correct. It doesn't matter whether the investor has been involved in the bribe or not. But we would submit, of course, they are, and we will demonstrate that in this tribunal if needed. But the point here is that the policy rationales for focusing on the investment is the core of the agreement that a state has offered to any investor, right? And the bargain there is the receipt of the investment. And here there was no investment because it was void ab initio as a result of the corruption. And we don't enjoy highlighting the conviction of our own officials, obviously, to support our legal arguments. But the United States has long held that corruption is a scourge in the world and must be rooted out and vigilantly guarded against. And we are deeply committed to the rule of law, and we have a zero-tolerance stance on public corruption. And while claimant has sought to establish a papaya colony by what we think are rotten means, we are not a banana republic. Thank you.
You do recognize that you have a very substantial burden of proof on matters of bribery and fraud and the like, and I assume you are prepared to perform that burden.
Absolutely. Professor Bermann, we accept that we carry the burden of proof regarding our allegations, but it's, in our view, a burden easily discharged here. The record is clear, and indeed it can't reasonably be disputed that the claimant's investment was obtained through corruption of government officials, including, regrettably, via the misappropriation of funds meant for the Maui community. And a full trial of an independent court resulted in the conviction of government officials in relation to claimant's investment. And they actually signed the investment agreement, those people who were convicted. So demonstrably, claimant's investment was obtained through corruption, and we will make that clear.
Counsel, are
Please, go ahead. I'm next.
okay. Are you asking this tribunal to simply credit the conviction of these two government officials that was made by a local domestic court and to take that as fait acquis, essentially, in this arbitration? Don't we have an independent conclusion that we should reach in these proceedings based on whatever evidence you are going to submit that there was indeed corruption?
That's exactly right, Madam President. We don't expect this tribunal to accept it fait accompli, but we do expect this tribunal to credit an independent an independent court's assessment that a conviction could be upheld beyond a reasonable doubt. And we will present that evidence and the evidence underlying that conviction in this tribunal, and we're confident that the tribunal will see it the same way.
A couple of questions on paragraph 9 of the record, and if you read through the whole record, the only thing beyond rumors and suspicions are the following words. Yes, in paragraph 9. Two officials who signed the agreement were convicted of corruption. What was their corruption? They could have been convicted of corrupting anything. It's not tied necessarily to the agreement. And the rest is just suspicions and, grapevine rumors. So how do we know that these officials who got convicted for corruption weren't convicted in some of their cases?
Well, firstly, I appreciate the grapevine pun. Secondly, this was a misappropriation of funds that were due to the Maui community, and it was in direct relation to this agreement. These are two officials who were convicted as a result of signing this agreement and misappropriating funds. So the record is clear on that. And again, the culpability of the investor in this fact pattern is irrelevant. International law looks to the investment, and that's indeed what the text of Article 25.1 of the ICSID Convention asks us to analyze as well.
I just have another question. The paragraph 11 is reference to a district court. Now, every state has its own courts, which might be called county courts or district courts. It doesn't say United States District Court. And does it make a difference whether it's the one or the other?
I don't believe it makes a difference. I think it's a conviction for corruption, and I think that's the point here. But I think we can assume, perhaps, that it's a U.S. district court, not a local Maui court. But again, I think it's a distinction without a difference, because the facts and the evidence is demonstrable that the investment was procured with corruption, and that alone vitiates jurisdiction under the ICSID Convention.
Did the corruption occur prior or subsequent to the district court finding that that all of the permissions had been granted?
The conviction alleges and was the conviction was sustained on the facts that the embezzlement of funds were used to procure the permits. So the permits were procured after the embezzlement of funds. Quid pro quo.
Yeah, I'm saying, would you mind repeating that?
It was quid pro quo for the permits. The corruption was payments and embezzlement that resulted in the issuance of these permits.
But those facts would result in, you say, in the conviction of two people who signed the agreement were known at the time that the district court approved.
No. So the record is perhaps unclear on that point. The permits were approved, or the district court found that the permits were properly acquired in February of 2025. The convictions occurred in April, and it's a question of fact that needs to be determined when the actual knowledge of these fraudulent acts were uncovered by the government. There was a parallel process that was ongoing from the state and local officials and criminal jurisdictional folks who were looking into the crimes that were committed in parallel with this civil procedure, this civil claim, that was looking at really the main, and this goes to issue 2, so I don't want to take up time on this, but it goes to whether they were properly acquired, not whether they were valid. Our point is they were not valid because there was corruption in the making of those investments. But that was not before the court in February.
What's your theory as to why the decision of the district court is not decided between the same parties?
Yeah, well, so that gets to the res judicata point, which we will be happy to address after Ms. Day's principal submissions per the tribunal's procedural order.
One further question. There are bilateral investment treaties that expressly provide that an investment is not an investment unless lawful. Lawfulness is built in effectively to the definition of an investment within that treaty, and there are other bilateral treaties that don't do so. Now, because you didn't cite any such provision, I'm going to assume that there is no provision in this bit that expressly makes it requires that the investment be lawful. So I guess it's your contention that that does not have to be referred to in a treaty in order for a corruptly obtained investment to be disqualified. What are we to make of the fact that a bit was entered into in full knowledge that other bits provide that an investment must be lawfully made, and this one doesn't?
The United States has had a long relationship with the Republic of Tislandia, and happily this was a first-generation bid, so it was negotiated early on in the U.S. practice and was perhaps issued in the 80s. fact pattern is unclear on that. But irrespective, to your point, Professor Bermann, the fact that it doesn't include made in accordance with language like other bits, we don't need lex specialis here. We have a general principle of customary international law that prohibits corruption in the making of an investment and vitiates jurisdiction in international investment law. That has crystallized, right? We see that not only in Phoenix Action, World Duty Free. I mean, you can go back 20, 30 years where tribunal time and time again, including the metal-clad tribunal, recognize that a general principle of international law is that corrupt investments are not investments.
So those provisions are essentially superfluous.
Those provisions aren't superfluous. I think they matter on issues that are not necessarily already crystallized under customary international law, right? So they can, very importantly, narrow or expand the scope of jurisdiction on other issues outside of corruption. But when you have a corruption convention, and I don't know of any state that permits corruption pursuant to their own domestic law.
Is corruption the only circumstance in which we take that position?
I think corruption is a good mooring post for that proposition, and certainly corruption is the one that is before us here. As a matter of academic hypotheticals, I can think of perhaps some others, but really the point here is it was corrupt, and international law does not allow corrupt investments
I
to...
got it. Okay,
Could
thank
it
you.
be- Sorry, Counsel, I know we're peppering you with questions here. But to Professor Bermann's point about when treaties are actually explicit on this issue, could it be then that when treaties mention the lawfulness of the investment, that it may be because it can be looked at differently, maybe not as an issue of jurisdiction, but perhaps an issue of admissibility or merits? Does that, are these two potentially tied, and is that maybe an element of inquiry that we should pursue further?
I think it's an excellent question. I think it's answered in this instance by the fact that this is an ICSID arbitration clause, and that we need to proceed under Article 25.1 of the ICSID. And Element 3 under Article 25.1 of the ICSID asks us to look to see whether there is an investment as a matter of jurisdiction. And here, again, there is none. So we're looking at this at the jurisdictional stage. But I take your point that if we were proceeding under an UNCITRAL process or an ISDS process that was not governed by the ICSID convention, perhaps you can figure out ways to think about this as an admissibility question. Here, it's a distinction, again, without a difference.
Well, do you think it would be any different, in fact, in this case, if it were UNCITRAL?
I don't,
I don't either.
because I'll quit where I'm ahead.
Please proceed, Counsel.
Well, if there are
You have 20 seconds left.
I think he's done.
I will conserve my 20 seconds for rebuttal.
Thank you
Thank
very
you.
much.
Good evening. I'm here acting on behalf of the investor, and the investor was so concerned that he'd be faced with a banana republic that he flew a King's Counsel in from London to address this esteemed international tribunal this evening. We've just been treated to a survey of international law, but what I want you to focus on tonight are the facts, or rather the lack of any basis whatsoever for concluding that the investor was party to corruption, or indeed that something has happened here which taints this investment. And we need to look at the facts. In my submission, there are 4 reasons why this jurisdictional challenge should be dismissed. First of all, the state has the burden of proof of proving illegality, and it's obviously failed to meet that burden. Secondly, The illegal conduct now alleged is not illegal conduct on the investor's behalf, but at best conduct by his mother and the Maui's own officials. 3, we submit that Maui cannot rely on its own illegality to deprive my client of rights he properly acquired and protection he acquired. And fourthly, at best, what investigators are said to have uncovered would have been evidence of events subsequent to the agreement. So in short, we say that this jurisdictional challenge is not well-founded. Rumour and innuendo has dogged this investment since it was made, but that is based on a pure prejudice, in my submission, against my client. Nothing by way of wrongdoing has ever been proven against him. And that is not for want of the state trying to find something. You'll recall from the facts that an investigation was held following the discovery of the unfortunate death of Edmund. Presumably that was an investigation that was competently conducted and looked into all the circumstances in which the agreement was signed. At that time, there was no suggestion of any bribe by the investor that had led to the entry into the agreement. Indeed, you still don't have any evidence to that effect today.
Counsel, isn't the submission of respondent that the bribery allegations or these improper payments were made, that they only learned of them after this investigation was conducted? And if so, then what is the relevance of the investigation? And shouldn't we consider the events that occurred after the investigation?
Yes, you obviously need to consider everything, but I ask you to reflect on this. The state has had now a number of opportunities to investigate this matter. None of those have ever led to a single piece of evidence linking my client, the investor, to payment of any bribes. Even following the second investigation, what happened was that the mother was charged by prosecutors and she was then convicted. The fact pattern says that the officials couldn't pin the bribes on Mrs. Patton. And what the state is not allowed to do is say to you, well, there's corruption, without identifying the nature of that corruption and the proof that it relies on to prove. So as things stand, there is no evidence on which you could reach a conclusion either that the investor or his mother were involved in any corruption. We then have the conviction of 2 officials for corruption. We have no idea as to what was the nature of that conviction, and it cannot be right that the state can come before you and deprive the investor of protection simply by using the word corruption, basing that on a conviction without linking that in any way to the investment.
Well, one question on this. One of the things that your learned opponent said very repeatedly was that it doesn't matter who committed the bribe, who committed the corrupt act. The commission of a corrupt act in connection with an investment is enough, okay, to disqualify the claimant. I was a little surprised to hear that.
Yeah.
What is your view on that matter?
Well, we would rely on the case law that said that where the state is complicit in illegality, it cannot invoke illegality of the investment to defeat jurisdiction. So we would rely on that. But as a matter of fact, it's even worse in this case because there is nothing at all to link the investor, first of all, to this, but there's also nothing to properly set up a case that this investment was entered into on a corrupt basis. The bribes that are referred to are said to have been paid in order to procure the permits. But we also have absolutely no information about what these two officials were convicted of, how that said to taint the investment. So as a matter of principle, the state cannot rely on it, but also on the facts, the state cannot rely on it.
I was just focusing on the question or the assertion that a corruptly obtained investment is not an investment irrespective of who committed the bribe.
Yes.
And I'm asking you what your view is on that matter.
Well, we wouldn't agree with that. We would say that otherwise you'd be permitting the state to rely on its own illegality to deprive an investor of protection if the investor didn't have anything to do with that corruption.
Thank you. Looking then at the issue of the timing of this, I would ask you to look at and consider the fact that what investigators are said to have uncovered is evidence of events subsequent to the agreement. And as we know from decided cases, the alleged illegality must arise in the making of the investment before it can qualify as a potential jurisdictional hurdle. Any illegality that arises subsequently during the performance of that investment would not be a jurisdictional obstacle, but might at best be relevant to merits or damages. And we say that the state submissions conflate and confuse those two things, because at best, what we are looking at here is some sort of vague allegation that further down the line there was some sort of misappropriation of funds in order to approve and secure the environmental permits. We don't know what the nature of that was, but that is after the investment has been entered into. It's during the performance of the investment. And so even if that was proven, and my submission would be that you do not have sufficient information to and evidence to find that that is proven, that would not be sufficient in principle to deprive my client of the investment that he's made. He made this investment relying on the protections that it gave him. There is absolutely nothing in this fact pattern that says that he should be deprived of that protection. And we also have, going back to the history, the fact that the state has tried through other means to get out of this investment. It's been to the state court, it got knocked back on that, and then in a flagrant breach of the agreement, it took the law into its own hands and passed a law removing my client's investment in an unlawful way. So if anyone has acted unlawfully here, it is the state and not my client. And it is now perverse that the state comes before you and asks you to throw out this claim at the jurisdictional stage. As I say, that would be to permit the state to rely on its own wrong. And therefore we say that the tribunal should see through that and robustly dismiss this jurisdictional challenge.
Thank you, counsel.
Thank you.
I think we have 5 minutes of rebuttal for the respondent.
Thank you, Madam President, members of the tribunal. A few quick points on rebuttal. First, to the point that the state should not be allowed to rely on its own illegality. This is not the state's illegality. A state is a state. These are two corrupt government officials who are not acting on behalf of the state. The state is not relying on its own illegality. We are horrified that our government officials committed these acts, and they are being prosecuted, were prosecuted, and are now sitting in a prison. This is not the state relying on its own illegality. We heard nothing from my learned colleague on the ICSID Convention. Not one word on Article 25(1), on the actual jurisdictional mooring post that this tribunal must look to satisfy itself that it has jurisdiction. Not one word. We also heard not one word on the policy rationale for why we look to the investment and not the investor, which is the benefit of the bargain that a state has offered to allow the incredible cudgel of arbitration without privity.
I have a question, which is, on what basis do you maintain that the state is not responsible for actions taken by its officials? Is it your contention that they were acting beyond the scope of their employment, and therefore the state is not responsible for what they did? But they are state officials.
Of course, they were not acting in their government capacity when they committed corruption, and the state has taken responsibility and prosecuted them to the full extent of the law. And let's look at the facts, because a lot has been said about I think my learned friend said, there is nothing at all linking the investors to the corruption here. Well, that's not what the facts bear out. And if you look at paragraph 8 of the facts, right, and we'll do a close analysis here, because I know the tribunal is concerned that this is too harsh a sanction when the investor is not in some way implicated, right? It's not just rumors and innuendo. The facts make it clear. Investigators also uncovered evidence that Sean's mother had later persuaded the same officials to misappropriate community funds previously earmarked for the papaya restoration initiatives to secure the permits for the papaya colony. The next sentence is prosecutors filed charges against Sean's mother and several government officials, although they couldn't pin the bribes, right? So just syllogistically, investigators knew she was involved. They actually brought a claim against her, and bribes were involved. So the tribunal will have evidence on this. But our point remains firm that if the investment is corrupt, there is no investment. It is void ab initio.
Counsel, I want to go back to Professor Bermann's question. And you said this is not an instance where the state is relying on its own illegality. And I'm struggling to understand the distinction that you're making. And I haven't heard from you anything explaining why these two government officials were in fact not acting in their official capacity. So can you illustrate for us maybe what would be a situation in which a state, is relying on its own illegality?
And to follow up on that, how do we know these officials weren't the agent of the state in taking the bribes?
To my knowledge, it is not the policy. It is not the policy of my government to allow officials to take bribes. They are not acting in their official capacity when they do so. And if a state were to rely on its own illegality, I'm sure the tribunal can come up with better hypotheticals.
We'd appreciate if you did.
Than I can. The fact pattern wasn't enough. If a state were to expropriate an asset and then rely on that expropriation to commit a further violation of international law. So they use that asset to violate full protection and security or another obligation. Then you could say the state is relying on its own illegality in furtherance of another investment violation. But here, clearly, the state is not acting these officials were not acting in their official capacity when they took bribes from Sean's mother.
How do we know? How do we know they weren't acting as the agent of the state? And the state perhaps took a commission on the bribes.
If the tribunal needs, we can provide fact witnesses and you can
Okay.
put those questions.
Okay.
Yes, I'm focusing on the line in the record that although prosecutors couldn't pin the bribes on Mrs. Hatton. Now, I think the weakness of your case is the inability to prove that the investors were aware themselves of some corruption that someone was committing for whatever reasons to see that it got approved. I shouldn't be telling stories, but I sat in a case, Vantage Deepwater, tried for 3 weeks in Texas. That was an American company that had a contract with the Brazilian oil company. And if you've ever been involved in these, it was called the car wash corruption. And the American company was found not to have been aware of internal Brazilian corruption that for specific reasons among those people, they wanted to, they got rid of the contract. And of course, the claimants satisfied the majority of the tribunal that there was no knowledge of corruption by the company that had this contract. It was going on internally for specific reasons within the Brazilian authorities. And you don't have proof, and
I take that very good point. I take the point, Judge Brower, and if the law required us to look to the mens rea of the investor, we would do so. And here the law doesn't require us to do that. Here the ICSID Convention is very clear that the parties need to have made an investment. And the investment was demonstrably procured through corruption, and therefore there is no investment. And I will only say that the standard of proof for a criminal prosecution brought against Mrs. Patton is far higher than the standard of proof that I need to discharge to demonstrate that there was corruption in the making of this investment. So the fact that the prosecutors couldn't, quote, pin the bribe on Mrs. Patton, notwithstanding a grand jury found probable cause to bring the indictment, that is irrelevant to my point. My point is there's plenty of evidence, demonstrable evidence, certainly more than nothing at all, implicating all these parties, and certainly 2 convicted officials who signed the investment agreement, that the agreement itself, the investment itself, was tainted by fraud and corruption, and is therefore not permissible to go forward under Article 25.1.
Okay, let's finish him.
Yes, I think your time is up, counsel. We will now move on to the question of the admissibility in relation to the validity of the permits with counsel for claimant.
Thank you. So this issue is whether the validity of the environmental permits, which is the main defence that the state seeks to run, is admissible given the earlier decision of the district court. And I wanted to just start with some facts about which there is no dispute. The state raises no defence to the substantive points. There's been a gross violation of the treaty. The investor made a large investment on the basis of certain protections, which the state now seeks to remove. And the way in which it seeks to remove that protection is to rerun issues it has already lost on before. And in particular, it seeks to persuade you that there are no permits in place for the project, and hence the project is not protected under the treaty. And that is an issue, as you are aware, which Maui already initiated a decision on before the district court. It brought those proceedings, and it lost that issue after what's called a comprehensive review of the evidence before it. So we say that in those circumstances, a collateral estoppel arises, or as us Brits would call it, an issue estoppel, And we say that that principle applies both under international law and under US law. So it doesn't matter which law you choose to
Do you have any
apply.
authority for collateral estoppel being recognized in international law? Collateral estoppel is not observed in the vast majority of jurisdictions, do not recognize issue preclusion.
Well,
Now, if you want to apply American law, I understand.
Yeah.
But you've invoked international law, and I'm having a hard time situating collateral estoppel in international law when the great majority of jurisdictions do not even acknowledge it.
Well, I think, as some of your own learned writings have set out, under international law, which, by the way, is the first search that comes up when you search this on Google, that international law often may call this res judicata, but actually when you look at the decisions, it sometimes can be in the form of a what may be known as res judicata, not an entire proceedings that's been the same, but actually an issue that's been the same. So we shouldn't get too hung
Well, that's a
up in my
misapplication of the term res judicata.
submission. It can be, but when you look at what international tribunals have decided, sometimes in effect they've decided that an issue
In effect, okay.
that an issue that's already been decided. And let's stand back from it and think about it from a first principles point of view. Because it can't be right that a state who has already gone to another competent tribunal or court and put its neck on the line and said these permits are invalid, has got the wrong answer, has then gone forward and flagrantly terminated the treaty in the agreement in breach of the treaty rights, then gets to come before this tribunal and say, hey, we'd like a second shot. So in my submission, whichever way you look at it, this is not something which this tribunal should permit to be rerun. You also have decisions such as Lau Holdings, where it was said that re-litigation of an issue of law or fact that was raised, litigated, or actually decided by a judgment in a prior proceedings between the parties shouldn't be allowed to be rerun, regardless of whether or not the two proceedings are based on the same claim. So the fact that these are slightly different claims doesn't matter. What matters is that the issue that is sought to be raised is exactly the same.
And the parties must be the same.
The parties must be the same, but we don't have any issue on that. We also have a final decision. And the requirement for identical issues doesn't need to amount to exactly the same claims as long as the issue decided, quotes, by necessary implication in the first action is enough to preclude the second action. Now, no doubt when my learned friend stands up, you'll be treated to a lot about the evidence subsequently discovered. And no doubt he will focus on saying that that means you should see things in a different light. I have two answers to that. First of all, some of the ground that we've already traversed on issue 1. There is nothing beyond rumour against the investor, either first time around or second time around. There is nothing to suggest that the investor did not properly obtain the environmental permits. We've been over that ground. There's also nothing which suggests that there's an entitlement to rerun those arguments before this tribunal. You have no explanation as to why it was only in the course of the second investigation that evidence is said to have been uncovered, which later didn't even stand up against the investor's mother. But the state doesn't come before you and say, well, this evidence was hidden or covered up, and we couldn't have brought it before the time of the first court hearing. They had their chance. They did a full investigation before. they initiated those proceedings. They no doubt were represented by the same excellent counsel, both in the state court. They had all the forces at their disposal, and yet they could not make this allegation stand up.
Counsel, would you accept that if we were to be presented in these proceedings with evidence, albeit after the investigation, uncovered after the investigation and after the district court proceedings, that these permits in fact were procured in a way that was inappropriate, that they were not validly obtained, that is something that we should take into account in our assessment of this question of admissibility?
Well, first of all, you don't have that evidence. Secondly, obviously it will depend on the exact circumstances, but there would have to be a very good reason. The mere fact that you've discovered it after the event shouldn't be sufficient. You would have to show some kind of complicity or cover-up by the investor to prevent it coming out. Otherwise, there is no finality in litigation. Somebody could come along and say, well, I didn't know this at the time, so I'd like to reopen it. That isn't in and of itself sufficient. And that's why I was emphasizing that there was a full investigation done first time round. There's no explanation before you as to why that didn't uncover what's said to have been uncovered second time round. And so we say, no, it doesn't make a difference. There's nothing here that suggests that you should look at it in any different light.
Is there any, can you give us a circumstance in which you would allow subsequent evidence to be invoked to defeat collateral estoppel?
Well, not off the top of my head, because on these facts there simply isn't anything. So it would be dangerous, and certainly it would be something that would open a door that should be kept.
Well, doubtless
shut.
it would be a dangerous door
absolutely.
to open for issue preclusion's sake, because it would seriously undermine it.
Yes.
But I can imagine that collateral estoppel might be set aside in a circumstance in which the subsequently learned material is of a public policy character.
Yeah,
and corruption
yeah.
could, but that's...
Yeah. I mean, certainly collateral estoppel is an equitable doctrine.
Yes.
And therefore a party has to come with clean hands. So that might be a circumstance in which, but there is no suggestion here that the failure to uncover it during the first investigation was somehow linked to something my client did or didn't do.
Thank you.
So I would ask you to strike out this attempt to resurrect the same issues before you.
Thank you, counsel.
Madam President, members of the tribunal, my learned friend argues that this dispute is inadmissible here, having already been adjudicated by the U.S. District Court in Hawaii in February 2025. And just, I want to focus on what that decision held. That decision held that claimant, in fact, quote, acquired all necessary permits. The distinction here is we are not bringing that before the tribunal. We're not asking the tribunal to opine whether claimant acquired permits A, B, and C. We're asking the tribunal, if it's not with us on the jurisdictional point, which it should be, to assess whether those permits were validly obtained. It's a difference that is an important one here. And before I go into my primary submission, I just want to lay out that I'm going to address you hopefully on 3 points. One, the applicable law, which I think there's been some confusion on. 2, the content of that law, which there's also been some discussion on. And then how that law is applied to the facts. So with regard to the applicable law, as Professor Bermann has pointed out, and I have Googled too, a tribunal has several options to choose from here, right? They can look to the law of the seat, which is DC. They can look to the law governing the contract, which is US law. They can look to the law of probable enforcement, which I thought was interesting, which is anywhere, right? And they could look to the law chosen by the tribunal as being most appropriate to resolve this issue. And given its definitionally international character, international arbitration lends itself to a consciously more cosmopolitan approach to res judicata, and I'm quoting there. And we submit that international law should govern this question. And international law, a consensus has emerged that res judicata is a general principle of international law consistent with Article 38 of the ICJ statute. And if you look at international law first, and I can get to a US submission if the tribunal would like to bring me there, but under international law, the fact that my learned friend said these are slightly different claims and they don't matter, well, that's not what international law provides. It does matter. International law would state that a right or a question or a fact distinctly put in issue and distinctly determined by a court of competent jurisdiction, that is the test. And then you go into the triple identity test, and I'm quoting there AMCO Asia v. Indonesia. But there are a wealth of cases that look to that particularity. So as to the specific content of that test, of course, you look at the triple identity test, you look at parties, object, and cause, and that was well borne out in the partial award in the A cases and the B61 case at the Iran U.S. Claims Tribunal. And if you apply that test here, that triple identity test, you see that it fails. Claimant's submission would fail. That standard's not met.
I'm a bit confused here. One of the differences between res judicata and collateral estoppel is that the claims do not have to be the same in collateral estoppel. So I think you've been describing res judicata, but what is being invoked is issue preclusion. So I'm puzzled.
Well, we also find no source of law for collateral estoppel.
Okay, that's another matter.
Well, that is the matter. It would guide the tribunal's ability to resist a challenge later as to exceeding its scope, right? I mean, the law is clear, and whether you look at international law, which we submit as our primary submission, if the tribunal were to apply U.S. law, that would be a different point. But with regard to issue preclusion, just not fighting the hypothetical, if it's issue preclusion we're after, then we would need to take a sounding on whether we would admit that the permits were obtained, which is the only question that the U.S. court found, right? That they were obtained. A, B, and C.
Counsel, my understanding of the fact pattern is that they were properly obtained. And I'm looking
Properly
at
acquired. So
properly
the
acquired.
signatures were all there, the registration was on time, and they were delivered to the clerk, et cetera, et cetera. All of the formalities existed. That's the civil law point, right? The question that was not brought before the court was the validity of those permits. And that is the question that is squarely before this tribunal if it's not with us on the jurisdictional point.
Well, if it was invalidly issued, how could it have been proper?
That's exactly right, but that's not the question that the District Court of Hawaii was able to reach because that was not presented before them. So clearly the triple identity test is not satisfied here. And let's just, for sake of argument, look to American law, U.S. law. If the U.S. law were to apply, then you would apply the conditions under res judicata, which is whether there's been a prior litigation of the same cause of action. So here that doesn't apply. The same nucleus of operative facts. Here, again, the same nucleus of operative facts are not at issue. One is a question of corruption and invalidity of a permit, and the other is whether those permits were properly acquired.
What does proper mean?
That's a good question.
If there are no further questions, I'll reserve the remainder of my time.
Yeah, thank you.
Thank you.
We're going to proceed with a 5-minute rebuttal.
So, two issues that I'd like to deal with in reply. First of all, the suggestion that the issue wasn't decided by the district court, and the distinction that was put to you of failed to obtain versus failed to validly obtain. My submission is that that is a distinction without a difference, and as you have already pointed out, in the fact pattern at 6, what was put to the district court was a failure to obtain proper environmental permits, and then the court ruling is that Mr. Patton had in fact properly acquired all necessary permits. And so you can't just rerun and reframe arguments in this way. And so the state is seeking to run precisely the same issue.
Well, I know I questioned the distinction between proper and valid.
Yeah.
But collateral estoppel only applies to issues that were actually litigated.
Yes.
And if the validity issue was not actually litigated, then don't you have a collateral estoppel problem?
In my submission, no, because properly acquired equates to validly acquired.
Yeah, but we have to look at what the issues were before the court. And it appears that validity is not an issue that was put to the district court. Whether it should or should not have been, or whether we read it into proper or we don't read it into proper, what we need to know is what issues were actually litigated.
Or should have been litigated within the compass of the issue that was before the court. Because otherwise a party could come along, it would drive a coach and horses through issue of estoppel, because, which we still have in England, coach and horses. So, yeah.
I think the one of the potential questions here is whether the scope of the investigation itself, not just the litigation, is relevant. And if the issue of validity was considered even within the scope of the investigation and ruled out, does that potentially inform that question of issue preclusion?
Well, that's why it's dangerous to go into this level of granularity, and that's why the rule's very clear that it should apply in a broad sense to the issue that was raised or any arguments that could have been raised whilst covering that issue. And that has been decided against the state, and it is not open to it to flagrantly breach the finding of the court by terminating the agreement in the way it did, and then to try and run that same argument in defense of its own actions.
I do want to just underscore that collateral estoppel requires that the issue have been litigated.
Yeah. Yes.
It requires that it have been litigated, and if invalidity was not litigated, there's no collateral estoppel as to it.
Yes, but if you look at the fact pattern here and the findings of the district court, we say that the ruling that he had properly acquired all necessary permits does encompass any arguments that can be made on that issue.
I'll leave it there.
Yeah. The only point that I'd like to make on US law and international law, we are arguing issue estoppel or collateral estoppel, and we say that both US law and international law, equity transcends all those boundaries and must indeed apply. It's a principle that should apply throughout, and one can't seek to redefine the vast amount of law that there's been on this issue to try and narrow it in the way that's been suggested that you should. Thank you.
Thank you.
Thank you. I believe this concludes the argument portion of this hearing. Perhaps I'll just start by saying thank you to both advocates for the excellent work that you did. Really great advocacy on your parts, and certainly would make the lives of a tribunal very difficult. And I believe this is the portion of the event where we exchange some thoughts and comments. So I'll start maybe with Professor Bermann.
Okay, I'm going to be selective in my comments. The first thing I want to say is, Patrick, I still remain appalled at the idea that the mere fact that a permit was obtained corruptly is enough to disqualify the investor without any necessity to show that that investor was somehow involved. I mean, just imagine you have an investor who makes an investment and some corruption occurs for which that investor is completely not responsible. I don't see how you could say to that investor, you're not entitled to advance your claim, because this permit was obtained corruptly through someone other than you. I mean, that's very troubling to me. And it's not, I mean, I think the investor must be implicated. That has been my assumption. You can correct, I'm sure you will correct me if I'm wrong, but I always assumed that the investor must be implicated in the unlawfulness. And the second and last thing I want to talk about is actually issue estoppel, believe it or not. Because what I raised with you was really a serious question in the case in which I sat, where collateral estoppel was invoked, and the question was immediately raised as to whether international law encompasses issue preclusion. And as I mentioned, I think it's very tough to establish that. It would have to be a general principle of law. And by definition, a general principle of law is one which has attracted something resembling a consensus. And there is no consensus at all over issue preclusion. At the end of the day, I will just tell you for information's sake, we had to decide what law governs the collateral estoppel issue. It wasn't necessarily international law. And we actually, you were on that tribunal. It was a question of whose law governs the availability of collateral estoppel. Whose law governs whether it is or is not available. And as Jim, if I can point the finger, as Jim will remember, we ended up saying to ourselves, well, look, we're sitting in Houston, okay, we're sitting in Houston, and Texas has everything to do with this case, and the Texas court has already made a finding on that issue, and we were extremely reluctant as a practical matter to deny collateral estoppel effect to a decision made by a Texas court who would be in a position to annul our award as we were sitting in Houston. But I raise this just to say there really are some very important issues out there that international law may or may not embrace. And if it doesn't embrace it, then we do have to decide what law should we apply. That was raised earlier, I think, by you. The law of the seat, the law of the place of probable enforcement. Or was it Patrick? The law of the place of probable, sorry, Patrick. The law of the place of probable enforcement, the lex causae. It's really an interesting, it arises commonly that we have an issue such as that, which could be, I hope you noticed, it could be decisive. If collateral estoppel was granted, that would have been pretty decisive. So it's just a wake-up call, at least it was to me, and I think Jim, that we have, wow, some serious hidden choice of law questions on pretty decisive issues. So I like that part of the case, and so I thank you for including it. That's all I have to say. Thanks, Samaa.
Thank you. Judge Brower?
Well, basically, you have, with the finding of federal court or a United States court operating under our law, excuse me.
Do we want to give them a question?
You hear me now?
On to our comments? That's not on the
Okay.
agenda.
Sure.
It's fun.
Yeah.
But when you're getting then moving to international law in terms of a bilateral investment treaty, does the law that would apply in the domestic jurisdiction necessarily apply? Because you're taking a case that was decided in a domestic jurisdiction, now you're looking at a different situation, a different venue, a different application of the law. And doesn't it make sense that because international law abhors corruption, that they can just disregard it if it's not? I mean, I think you got a point, my friend. I've been to talk about issue preclusion for a point. I have been an amicus with two other people, asked by the lawyers for the $50 billion plus rising every day UCAS case, which has been in the courts here, but with the UCAS lawyers basically wanting to retry the entire case as it was all the way up through the Supreme Court of the Netherlands, and the district judge, who was then the chief judge, allowed that to happen. And in a footnote number 17 said, well, I don't have to decide on the issue preclusion because we've decided a different way. And basically what we put into the United States Court of Appeals for the District of Columbia Circuit was, you're wasting everybody's time. This has been, you should issue preclusion. It's been decided in a respectable place. And actually the court didn't say, oh, that's what you should have done. But when it sent it back to the district court, said, you should consider this. Mm-hmm. You should consider this. Mm-hmm. So I think that somehow you're in a different situation if you're trying a case under a bilateral investment treaty, which one way or the other international law will apply, and should be freer to sort of examine, which is what George is saying, mm-hmm. examine what actually happened here. Mm-hmm. And I'm not sure if you stayed in the federal court system and you went up on appeal and you didn't know all this stuff, and then you go up to get a petition for certiorari granted, you're going to lose all the way. You're going to lose all the way. There's no way of getting around it. Mm-hmm.
Your turn.
Well, I'll keep it brief because I think we're short on time, and we want to make room for questions and answers. I joined Professor Bermann on the mens rea for the investor point, which I also think was, of course, a point that was difficult for the respondent to deal with, and one that we would certainly struggle with as a tribunal. Just two more comments from me. I thought it was an interesting fact in the fact pattern that didn't surface as much in the argument, the connection between the rapid legislative change that occurred only 1 month after the court decision on the permits. And I thought the timing of that was, certainly interesting from the government's perspective. And then lastly, perhaps just maybe a broader point, which is that something that I certainly would struggle with is this idea that a tribunal would have to adhere to a domestic court decision in any circumstance. I mean, we've all been in situations where, domestic court decisions can come in a lot of different forms and shapes, and sometimes, in questionable ones, perhaps, to put it charitably. And so I think one argument could be that it cannot be that a tribunal sitting here would be automatically bound, whether it's a question of issue preclusion or res judicata or whatever you want to call it, that they have to just take in whatever a domestic court has said, as just perhaps a broader, more policy type point. Before we turn it to the audience, I would like to invite our esteemed advocates to respond, to rebut what they have heard from the tribunal.
If you can.
I'm shocked that Professor Bermann is outraged at a position that the United States would have taken.
That's it?
Very effective.
More seriously, on issue estoppel, I actually agree with you in the sense that more often than not, you'll have a court decision, a local court decision that's in favour of the state. Obviously, here the fact pattern was the other way around, but it would be a dangerous precedent, I think, to set. And I think any legal system sometimes struggles with where the boundaries are of when someone is stopped. Res judicata is pretty easy to apply, but beyond that, it becomes much more difficult.
I think you both deserve a round of applause.
It's very tough.
Yes.
Very tough.
Yes. We were a very hot bench.
We were a hot bench, yes.
So let us continue. They're not quite done yet, and we very much invite comments or questions from the audience.
And we've always had them.
Scott.
I'm happy to kick off, but I just wanted to observe there were two dogs that didn't bark, and in particular they didn't bark at the respondent. And so one of them was, well, what's the investment, right? Is it the permit,
Right.
or is it the contract? And if it's the permit, well then the corruption doesn't actually go to the investment. And that was a dog that didn't bark. The other one.
But the property had been bought.
Yeah, that's how I understood
Yeah,
it.
according to the problem, the property had been bought already. So I viewed that as the investment.
Right, not the permit.
No, not the permit.
That was one. The other one was, if there's no issue estoppel, why didn't they go back to the district court and say,
New
now
evidence.
invalidate them because there was corruption, right? And so, and does that matter? And so those were two debates that
Yeah.
would have been interesting, but I'm not going to ask you to respond.
No, well, they're a banana republic, so they just pass their own law. They don't go back. Like, that's the
Papaya
point.
Republic.
Yeah.
You're comparing apples to oranges.
Yeah, that's good. That's come on.
Yes, Tom.
It occurred to me, Anneliese, in your submissions.
You got a microphone.
Thank you. It occurred to me, Anneliese, in your submissions, at one point you said an argument that should have been raised in the ensemble discussion. And it struck me that that may have been a reference to the English rule of Henderson. Which English practitioners know well, but others in the room
No.
don't know, which is the rule, and Anneliese will correct me when I get it wrong, that if an issue should have been raised in the venue, in the forum, but the party failed to litigate it, failed to raise it, they are stopped from bringing it in the future.
That's a different estoppel.
Yeah.
Indeed,
That's a very different estoppel.
but I thought you may be referring to that when you briefly did say should have been raised in that context, and it perhaps adds a nuance to the estoppel discussion.
Yeah, no, that's absolutely right. I'm afraid that's my born and bred coming out there. But actually, even within English law, it's sometimes very difficult to know where the boundaries are. And there's certainly a plethora of cases of people trying to test what those things mean. And I remember as a young advocate sort of sitting there sweating, thinking, I don't really understand this. And then a judge said, well, no one really understands it. It's just kind of, you know, as it goes along. But I can see the difficulty under international law where you have different systems. It always surprises me. I've been doing a lot of Bermuda form cases, how different, you know, US or New York law is to English law. It's a fascinating topic, let alone all the rest of the jurisdictions in the world.
Yeah, and I think the closest cognate under U.S. law might be in re leo in the Second Circuit, which of course didn't govern here. It was in the D.C. Circuit and federal law, but there they talk about, in the res judicata context, they talk about evidence that should have been discovered that was not presented, right? So there's a diligence component on the party moving for res judicata, but that was a dog that also didn't bark, so happily.
Do we have any other questions or comments, reactions?
It's not a hot audience.
Yes, we have.
Thank you. I thought one interesting debate was about whether the government could just disavow the conduct of the officials.
Yeah.
Because, and certainly here in the U.S., we've all had to think about that a lot. There was a Supreme Court ruling last year about presidential immunity from unlawful acts. But notwithstanding even that ruling, I think if a government official does an act, later is convicted for that act having been illegal, when the act was taken, he or she was still acting in his or her government capacity. And the fact that later that person might end up in jail because, you know, he or she took a bribe doesn't nullify the conduct that was taken when that person was in office. At least that's sort of how I view it. So, yes, it's easy to say, well, we prosecuted that person, so, you know, it's no longer our conduct. But I don't think it's that easy to say that way.
Agreed.
And relatedly, I mean, that's a very interesting point indeed, which we forgot to mention in our comments about how difficult that argument was, I think,
Yeah.
for the respondent. And relatedly, does it matter whether it's 1 or 2 or 4 or 10? We did not hear anything about that from counsel.
But that is certainly, it would be argued that they were on a so-called frolic and detour, or whatever we used to call whatever it is you do outside the scope of your employment. That certainly, Patrick was, you know, it's right.
Yes.
I think. But I raised the question, but I think I would come to the conclusion that they were acting beyond the scope of their employment.
On the choice of law question, I vaguely recall that in the United States, the res judicata effect, collateral estoppel effect of the judgment is governed by the law of the jurisdiction that issues the judgment. And that's one of the ones that wasn't offered.
Yeah, that's true.
We were both pandering with
Yes,
our, I agree with you, Joe. I mean, we were both pandering to Professor Bermann's rubric in his seminal article on the subject.
So implicated here.
Know your tribunal.
I don't know. This is.
I have to confess, Samaa, when you invited Patrick to provide other examples of corruption. Somehow the image of F-15 fighters flying out of Saudi Arabia.
ouch.
Yeah.
On a less controversial topic than that, I was interested in the short dialogue, Patrick, that you and George had regarding jurisdiction versus admissibility. And I take the point that in the context of this case, it wouldn't make a difference. But I take it would in other cases in terms of review and
Yes.
possibly other reviews.
Yeah. Well, I would say this. First of all, the standard of review for jurisdictional issues is meant to be stricter than admissibility issues. And the other thing is, at least in principle, admissibility issues are curable, and jurisdictional issues are not curable. Those are two salient differences. There may be others. But you can't cure a jurisdictional defect. But almost every admissibility question, or a good many of them, are ones that, like failure to satisfy preconditions to arbitrate. I mean, you can then go back and satisfy them. So those are the two I'm aware of.
Hi, just a quick question on Professor Bermann's book on the investor needing to be implicated in the corruption of bribery. The fact pattern here seemed to suggest that the locus of corruption or the government officials that were involved in the corruption were, as Patrick mentioned, were in fact the officials who signed that agreement. If corruption is implicating the agreement giving sort of consent to jurisdiction, and therefore this tribunal's role, why would it be necessary for the bribe to have been paid by the investor? Why is it not sufficient for the government's actors in that scenario to have been compromised? Why would that?
Well, because we're raising unlawfulness to deprive the investor of a claim that, by hypothesis, it would have been entitled to bring. So I have a difficult time, if you will, depriving the investor of a claim for a reason it has nothing to do with. And that's what this would be, at least under some hypotheticals. I don't know, Patrick, whether you really believe what you argued.
You'll have to appoint me and find out. But I think the point that I think I didn't perhaps make as forcefully as I could or should have, but I think I would underscore if I were given my third bite of the apple now, which is I think irrespective of the point on mens rea of the investor, I really want to highlight why the focus on the investment really matters, because if we agree with this concept of arbitration without privity, and that states are just opening arbitration to any qualified investor, the benefit of that bargain is an actual investment that benefits the state. And here there was none. And
Well,
that's why the ICSID convention is set up to focus as a jurisdictional threshold, as the gate, with investment. And it doesn't say anything about an investor.
Well,
That would be the state's position, not necessarily mine.
and that would not
Friends at
change
home.
my thinking. I think we're done, maybe? It's only 7:15, but...
Would you like to say something?
Yeah, thank you. Well, it falls to me to bring this event to a close. I have very little to add to this magnificent advocacy we heard. I do want to underscore that this is the 10th anniversary. It won't happen again. So I also, if you don't mind, Susan, I'd like to introduce Susan, David Caron's widow, and a great friend of the Praelium, who unfailingly attends. So, in honor of David. Good. And the last thing I want to say is, They wrote the problem, we didn't. Okay? So, thank you all for coming. Enjoy the drinks.
Thank you.